Judge Joe Sklarosky, running for retention on the Luzerne County Court of Common Pleas. And for me, retention is an opportunity to continue my public service. And thank you for this opportunity to talk to you and your viewers and readers. 10 years ago when I ran, I promised the citizens of Luzerne County that I would work hard every day and make every ruling based on the law and the facts and record before me. I like to think I kept that promise. I'm committed to public service. I'm proud of my 10-year record. I think it reflects hard work, and I think it reflects quality work. I'm proud of my record in the appellate courts, the decisions that have been upheld, and the affirmation of the reasoning in those decisions. So I'm proud of the quantity and the quality of my individual record. And I'm also proud of the fact that I think I've demonstrated an ability to work with my colleagues to try and make the Luzerne County Court of Common Pleas an efficient and effective and a quality court. And I think in the last 10 years, my colleagues and I have worked hard to try and rebuild the reputation of the Luzerne County courts. And my goal, and I'm sure I speak for my colleagues as well, is to have a common pleas court that the citizens of Luzerne County can be proud of. And I'd like to continue that work.
Obviously, everybody came in 10 years ago after a pretty tumultuous period on the court. Can you talk a little bit about some of the changes that have been made since you've been on the court? Maybe specifically in your own courtroom, but in a wider sense?
My approach, and I told my colleagues this when we got elected, was, we can talk and say all the right things, and certainly there's nothing wrong with that. But at the end of the day, my attitude was that we're going to be judged on our actions. And I think when it comes to being a judge on the Court of Common Pleas, that means showing up every day, working hard, because there are plenty of cases to be dealt with and to be processed. My attitude was the best thing we could do is show up, work hard every day, be transparent, and decide every case based on the law and the facts. And if we do that over time, we'll start regaining the credibility and the trust, of the citizens in the courts. And I like to think we've done that. As far as changes, certainly I think we've tried to be open to new ideas. You look at the consumer debt court that we started, the mortgage remediation program. Those diversionary programs I think have been helpful and effective. I'm proud of the fact that since 2014 I've overseen our direct treatment court and our mental health court. Right before I took over in 2014 as the supervising judge, we had been accredited by the state Supreme Court under the guidance of Judge Amesbury. Since then, in 2018, we were reaccredited. In 2020, last year we were reaccredited. So we're certainly proud of that, because that's a stamp of approval from the state Supreme Court that we're doing it the right way. We're adhering to best practices, and we're proud of that. So, and we're always, I think, as a court, generally speaking, open to new ideas. If a lawyer has an idea how we could better schedule or process cases, I think we're open to those new ideas and concepts. And I think that's important. Just because you wear a robe, you can't be afraid to consider new ideas and consider something that you might not have thought of yourself.
Now, your assignments have been typically on the criminal side. Is that true or not?
Recently, yeah. When I first started in 2012 and 2013, I was in the criminal division and the civil division, and I was on motions court. So every week I was either picking a civil jury or a criminal jury, or I had motions duty, and so I did everything. And over the 10-year period, I pretty much have done everything. But most recently, in an effort to consolidate our practices and have divisions, civil division, criminal division, family law division, juvenile division. I've been in the criminal division with Judge Vogt and Judge Lupus, and I think we've been pretty successful in focusing our energies and being more efficient in working towards divisions. And so in addition to being in the criminal division the last couple of years, I've been, like I said, since 2014, the supervising judge of our diversionary courts or specialty courts, which is every Friday.
Okay. Can you talk a little about those? Because we've talked to all your colleagues really about these different programs. Have they been effective? Should they be enhanced or expanded or going forward?
We have two diversionary courts that I oversee. First is our treatment court, which is our drug and alcohol treatment court for those offenders who pretty much came into the criminal justice system because of an ongoing drug or alcohol problem. That's been in place since 2006. And again, we were accredited by the Supreme Court for the first time in 2013. Since 2009, we've had a specialty court. We call it specialty court. It's a mental health court. And that's for offenders who have come into the criminal justice system largely because of a mental health issue. Some of them are co-occurring, where they self-medicate with drugs and alcohol. But it's primarily for those offenders who suffer from a mental health problem. In 2017, we started a veterans track. In looking at the data we had for our county, we really didn't believe we had a criminal justice veterans population to justify a full separate court. So we tried to think out of the box a little bit, and we created the veterans track. So if we have a veteran who comes into the criminal justice system in Luzerne County and they qualify for either the treatment court or the specialty court, and they want to be with other veterans, they could come into a veterans track. So what happens is they come into either treatment court or specialty court, and then if their choice is to be with other veterans, they enter the veterans track. We hold that as a separate court session, okay? We start with the pledge. It's just veterans. We have veteran mentors who help us out and help guide these veterans. So we've had that veterans track since 2017. To my knowledge, we were the first county in Pennsylvania to have a veterans track, and I think it was last year they actually created legislation approving of veterans tracks. But we did it with the approval of the AOPC when we started in 2017. But I like to think we were somewhat of a trailblazer in that regard.
One of the changes over the last couple of years has been bringing back the central court concept, which I'm sure has an effect on what happens in your courtroom. Can you talk a little bit about that and how that's been working?
I've heard people praise Central Court, and I've heard people be not so happy with Central Court, and I think that's an area where I think as a court generally, we've been responsive to suggestions on how to make it better. I do think it is more efficient. You don't have lawyers running all over the county to attend preliminary hearings. So I think that being centralized is more efficient, and I think by and large it's been a positive, administratively speaking, it's been a positive step. And there's an adjustment phase because, as you well know, we had it years ago, and then we got rid of it, and then we brought it back, and so there's always an adjustment phase for.
What are the nature of the complaints or the people who maybe don't like it so much? What is it they don't like?
Sometimes there's a backlog, so nobody likes to wait around forever for your hearing to start. So that's been a complaint that I've heard. And again, we tried to make adjustments to deal with that. That's probably been the primary one. Central Court, one of the benefits, I think, of Central Court is that it allowed us to have, assistant district attorneys involved. And, with the expectation that we get the assistant district attorney representing the Commonwealth, we get defense counsel there, we're more likely to have a resolution of the case earlier in the case, which I think benefits everyone. Certainly that does not always happen, but I think one of the benefits of Central Court is that you have that possibility. Where if a case shouldn't really make it past the preliminary hearing stage, it could be resolved there. And even if it does make it past the preliminary hearing stage, you're more likely to have a case that's likely to resolve at the common pleas level because you've had lawyers involved earlier in the process.
I thought, my understanding is the Central Court, the whole idea behind it was to help kind of cut down on that backlog of cases that were building up. Do you think it has had that, you mentioned there is a backlog at Central Court itself, but has it resolved the issue of the backlog at the Court of Common Pleas?
I think it has had that effect. Yeah, I think it has disposed of cases that should be disposed of there and not make it up to the Court of Common Pleas. I do think it has had that effect, and that, like you said, that was one of the intended, effects we were looking for.
Obviously, a retention election is quite different than the election you were in 10 years ago, which was kind of a free-for-all, right?
Yeah.
How are you campaigning, or are you campaigning at all? Or are you raising money, or are you?
I'm not raising any money. I go to community events more so than political events. I'm basically running on my record, which I'm proud of. I'm proud of the work I've done, quantity and quality. And again, I'm committed to public service. And hopefully the citizens will realize, I kept my promise that I made 10 years ago and decide that, I should be there for another 10.
Judge, how has or did the pandemic affect how you operate your courtroom?
The pandemic was certainly an enormous challenge, and there was a lot of uncertainty in the beginning. I think back to last March when it really hit, and we did the first lockdown, which I think was St. Patrick's Day, March 17th. And the word that comes to mind is uncertainty. But I got to tell you, I'm proud with the way our court handled it under the leadership of Judge Vogt. We, under his emergency orders, were able to continue carrying on the essential functions of the court. And even in the fall, September and October, we were able to conduct numerous jury trials. And I think, to my knowledge, we were the only county in Pennsylvania to conduct jury trials during that 2-month period before the second lockdown in November. We could not have done that. We could not have done that without technology. We had, because we had guidelines we had to comply with, right? We had and to this day, we try and follow all the CDC guidelines and other guidelines. Back then, it was the spacing. So we had jurors, I think we had 4 jurors in the traditional jury boxes that we have, and then we had the other ones, including the alternates, in the gallery, the one half of the gallery. And so for the jurors in the gallery, we had 2 big, television screens. We had wireless mics so that, because we all had to wear masks, so we could project and the jurors wouldn't miss anything, okay? We had cameras focused on the witness so that if you're a juror in the gallery, you're looking at a huge television screen in front of you and you can see the witness as clear as day. Because obviously we have constitutional standards that we have to uphold. But we were able to pull it off. And I don't know how many jury trials we tried in September and October, but I'm quite sure it was double digits. And It's really a credit to the citizens who responded to the jury summons. And I think it's a credit to the procedures that we put in place to allow them to feel comfortable to come and serve. They saw how seriously we took their health and well-being and safety, and they cooperated. So it's certainly a credit to them. And to have that many people who took their citizenship seriously and their duties as a citizen seriously was really encouraging and inspiring to me. Because that was an unknown. When we sent those summons out, we weren't sure what the response was going to be in light of what was going on. But it was really inspiring to see so many people take their duties seriously and show up for jury service. And again, with the technology, we were able to, get cases tried.
If and when this pandemic is over, how much of that technology do you think will stay in use?
Good question. And it's funny you should say it that way, because I had drafted back for last fall when we were trying cases during the pandemic. I had drafted instructions, and I was reading most of those this morning to this panel, and I said, no one has told me officially that the pandemic's over, so I'm sticking with these instructions. But that's a good question. We still have the monitors in the gallery, but because we no longer have the mandatory spacing requirements, we do have the jurors and all jurors in the box now, but everyone's got a mask on because and we still have the sanitizing stations and everything throughout the courthouse and the courtrooms. But at this point, the biggest thing that we're doing is everyone's got to wear a mask. And the lawyers, if they're speaking, giving an opening statement, they're far away from everyone, they can take their mask off. But pretty much at this point, it's just the masks.
How about the televisions and the microphones and speaking as someone who covered the courts, though it was a long time ago? Sometimes, depending on where you're sitting in the courtroom, hard to hear, hard to see. I mean, is there any plan or thought of keeping those monitors, keeping those microphones?
We still have the monitors, although the ones in the gallery we're not using right now because we brought the jurors back into the box. This morning, when I did voir dire, we had all the, I'm up on the bench and we had the gallery filled with the panel. I used the wireless mic because it's helpful. The lawyers have the option to use them if they want. I encourage them to use them. I have a big mouth, so I can kind of project. Some lawyers, not everyone's the same. Some lawyers don't have, the projection. They may choose to use them, but they're there. They're there to be used. The monitors that we have beyond the bar, in the court, are available for use. I know the Commonwealth in my trial today indicated to me that they were bringing up a projector because they wanted to publish a photo. I don't know why they wouldn't use the monitor. It's available. I don't know if it's a technological thing. We have had lawyers continue to use the technology, the big screens. But they're the ones who have to kind of try their case. It's my job. I let them know it's available. I know the district attorney's office has tech people that understand all that stuff and can decide whether or not they want to use it. But at the end of the day, I let them know it's available if they want it. And we still have it in case, God forbid, we have to, go back to some of our old protocols that we had, last year. So we have them.
Has the pandemic affected how you sentence defendants because of the conditions at the prison?
Good question. It really hasn't affected my sentencing because usually if the guidelines are pretty suggestive in requiring incarceration, that's the sentence I'm going to impose. Typically, if probation's in the standard range, I'm definitely leaning towards community supervision, obviously with appropriate conditions. But I tried not to let that sway me, in my sentencing decisions. yeah, I don't think it had much of a factor. Or much of an effect on it.
Is there, do you feel influenced by this trend to go with like alternative sentencing as opposed to traditional jail time?
I have always followed the guidelines, okay? And, you know, our sentencing code allows for many different types of dispositions. You know, we have probation, we've got house arrest, and, you know, we've got our diversionary programs, which I try and suggest to lawyers in cases where I think it's appropriate. If they haven't, for whatever reason, thought about it, I'll suggest it to them. Well, hey, have you thought about, this appears to be drug or alcohol related. Have you thought about diversionary court? Which offers just a tremendous legal benefit. The chance to get, and we're one of the few, if not the only, treatment court in the Commonwealth who offers a true diversionary court. Okay, many treatment courts, you have to plead guilty, and then instead of incarceration or some other sentence, you're placed in the treatment court, and you're supervised by treatment court. We have a true diversionary court in the sense that you offer a guilty plea, but it's never accepted by the court. What happens is it kind of gets put off to the side, and I place you on bail, ROR, under the supervision of the treatment court program. So that if you complete the treatment court program and you graduate, your charges are dismissed. That's important when it comes to your driver's license, your occupational professional license, things like that. Even your Second Amendment right even, is affected by a criminal conviction. We also, in addition to the dismissal, if you complete our Phase 5, which is 1 year supervision on a misdemeanor, 3 years supervision on a felony, you can earn expungement. So those are tremendous, legal benefits to someone. And you come in with 5 cases involving retail theft. That could be that's a big deal. So it's a tremendous opportunity for an offender who is who's got drug or alcohol issues, that keep bringing him or her back into the criminal justice system. And it's a lot of work, treatment court. But if you're really serious about dealing with your problem and looking for a second chance, it's a tremendous opportunity. So, I try and, suggest it to lawyers who may not have thought about it for their particular client. And that's it's just a tremendous opportunity. Tremendous opportunity. Point being that there are a lot of options built into our current law. And I think I want to say most judges look to incarceration alternatives in the appropriate case, with the appropriate offender.